Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer series. The Curious Lawyer is a fun walk down different paths of law. It takes you into areas that you don't encounter and deal with in your daily practice. We've covered topics from dog law to CIA law to presidential pardon law. And today, we're going to talk about the perfect crime. We're going to look at the interplay of different laws from the Constitution to acts of Congress, and we're going to see if it's true that there's a zone in America where you can get away with a perfect crime free from any judge or jury, free from any prosecution, because you can commit the perfect crime. And the question we're going to look at is whether this place exists in Yellowstone. So let's get going in this latest episode of The Curious Lawyer as we look at the perfect crime. Is there a crime spree free zone in Yellowstone National Park? What we're going to look at today is a legal overview of different constitutional and jurisdictional topics. And so we're going to look at the U.S. Constitution and the Sixth Amendment. We're going to look at the right to a jury trial, and we're going to look specifically at the vicinage requirement for jurors. And this is a rarely invoked and little known provision of the Constitution that looks to whether you're entitled to a jury pool from your local vicinage and how you define what that is. We're going to look at federal law relating to the creation of Yellowstone National Park. We're going to look at federal law relating to the federal district that covers Yellowstone. We will also then look at criminal cases emanating not from Wyoming and Yellowstone, but primarily from other jurisdictions that deal with these what we can call border disputes as to whether, because of the interplay of the jurisdictional requirements and the vicinage requirement, you can get funky borders, or what are known in the law sometimes as no man's land zones, where people can get away with crimes. And so the question we're going to ask is, has the conflux of these different laws created this Yellowstone twilight zone place where crime can be committed freely? So let's get going, but first we're going to go to a long time ago in a galaxy far, far away. We're going to go to the pre-Republic time. The 1500s in England. And this brings us to the common law, which gets us to questions related around jurors and vicinage requirements. And so if we go to England in the 16th century, before even the founding of the Republic, we get to the common law and we look at what was the problems plaguing the common law of the time in England. And one of the commonalities that occurred in that time period, given the quirks of jurisdiction and vicinage requirements for juries, which had existed at the common law for a long time, was that people would murder people in one county, and then before the person died, drag them across the border to the next county to let them die there. And because of the quirks of the law that required at the time that the entirety of the act, the stabbing and then the death and the murder, had to all occur within the same county, people would exploit that to stab someone on one side of a county line, drag them across the border, let them die on the other side, and get away with murder. And so you had these sort of perfect murders occurring back in the 1500s in England, and this plagued the country at the time. And so Parliament in the mid-1500s enacts positive law to start trying to remedy this and to deny people the ability to get away with this. And they dealt with that by creating juror requirements that allowed jurors to hear cases across counties. And so this then formed part of the backdrop that led to the founding of the Republic. And so in the early then American colonies, we had early problems already that arose. And so, for example, one of the earliest problems that obviously led to sort of part of the fomenting of revolution on our shores was the fact that the stationed British soldiers and troops, if they killed colonists or locals here, they wouldn't be tried here in what was, the American colonies at the time. They would be shipped back to England and put on a jury trial back in London in front of a London jury, not really a jury of the peers in terms of where the crime occurred, obviously. And so that obviously became part of what was known as the intolerable acts that fomented revolution and led to the American Revolution ultimately. And so what this shows is that by the time we got to the founding of the Republic, there had been a long common law history of struggling with the need to have local juries decide local cases for fairness, but also to deny exploitation of jurisdiction and locality rules to let people get away with things. And so the founders, at least, found it to be of paramount importance that if someone is going to be tried, it must be by a local jury. And this then brings us to our next slide, to federal jury citizenry and jurisdiction law and the creation of ultimately what's a conundrum. And so as we walk through the Sixth Amendment and some of the federal statutes, we're going to build up to this conundrum to answer the question of whether you can commit the perfect crime. So let's start by looking at a little overview of some of our historical legal concepts of venue and vicinage. Venue, of course, is the location for where a trial should occur, and vicinage relates to where should the jury pool be drawn from to decide the trial. So venue, we get that from Article 3, Section 2 of the Constitution. And as you can see, it says, "The trial of all crimes shall be by jury, and such trial shall be held in the state where the said crimes shall have been committed." From that, we have a vicinage requirement. And this was added because when the Bill of Rights was, before they passed the Bill of Rights, but when they were working on the Constitution, of course, at that point, we only had that, jury trials will be heard in the states. And the concern then became, wait a second, what about local juries? And what if we have unfair jury pools being drawn from other places? And so part of what was added to the Sixth Amendment as an amendment was to ensure local juries. And so the Sixth Amendment was modified to make clear, or it modified the Constitution to make clear that the jury has to come from, quote, "the state and district wherein the crime shall have been committed." And so at the founding of the Republic, the historical district really overlaid what a state was. Or if there were multiple districts, it was multiple districts within one state. And so you didn't really have a border crossing situation. And of course, the root policy here is that juries are instruments ultimately of public justice. And so a jury has to be representative of the community. And so the concern then was that we wanted to make sure that jurors would come from not just the state where a crime is committed, but also the district within that state where the crime is committed. So you have this sort of narrowing emphasis a little bit if you have multiple districts in a state to define it. And so let's now go look at, on our next slide, a little bit more detail about the Sixth Amendment. And so we see here in the beginning the quote from what was the proposed original language. And this is what gets at this idea of vicinage, which is sort of a historical term that's not used much. But it comes from James Madison, who had originally proposed the Sixth Amendment language. And you see here the language that he had proposed. "The trial of all crimes shall be by an impartial jury of freeholders of the vicinage, with the requisite of unanimity for conviction, of the right of challenge, and other accustomed requisites." Now, the framers found that vicinage was too vague, and it could be subject to too much debate and uncertainty as to what it meant. And so they actually then defaulted to the word district, which is why you see in the next bullet point down, we have the actual Sixth Amendment. "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." So at this point, as you can see, we've got the Constitution talking about the state. We have the Sixth Amendment talking about the state and district for the jury pool. So we've got venue and the jury pool established. But then the question is, what's a district and how do you define it? Well, that was left to Congress to define. And as the Sixth Amendment was being debated, as all the amendments were being debated, there was also then pending the then pending Judiciary Act. And part of the then pending Judiciary Act was to actually define the actual districts within the United States that would be passed by Congress. And so that was actually being debated. And so this then sort of starts narrowing as we come down the funnel from the Constitution to the Sixth Amendment to the Judiciary Act and districts. We're getting to this question of what happens if a district is defined to cross a state line? And what do you do if the jury then does not come from the state where the crime was committed, but comes from the other state, but that is within the district? And that sort of border problem, which is an odd problem, is one that we want to think about. And it's one that didn't exist historically because a district was coterminous with a state. And so you could always have constitutional fidelity to making sure that a jury came from the state and district where the crime was committed, because the district was always either the entire state or a subpart of a state. But what happens if a district slides over a state and the murder occurs in this state, but the same district, but the jury's pulled from this state? That's the problem we're going to get to when we start looking at Yellowstone. And so let's take a look at the next map. And here we can see Yellowstone National Park. And as we can see in the map here, it overlaps 3 states. And this is a historical, coincidence or unique aspect of how the national park has been laid down vis-a-vis state maps, but also it's been created by, as we'll see in a moment, some acts of Congress. And so you can see on the map here that the dark green is Yellowstone National Park, and you can see that the vast majority of it, almost the entirety of it, is in Wyoming. But you can see there in the lower left-hand corner, there's a sliver of dark green in Idaho, and then there's a sliver in Montana that goes sort of, up and over the top of our little dotted line there, which is the border of Wyoming. And so if we go to the next slide, we have amplified the picture a little bit, and you can see the sliver we're going to talk about today primarily in Idaho. And that tiny sliver of land is Yellowstone National Park, but it's in Idaho. And as it turns out, only 9% of the park overflows into Montana, which is about 260 square miles. And that little sliver in Idaho there that you can see in the bottom of the picture with the little arrow pointing to it, that's only 50 square miles. So let's keep going and let's look at the establishment of Yellowstone and how this happened that starts defining the problem we're going to get to. Yellowstone was established in 1872 as a federal national park. And you can see there, it comes from the U.S. Code, 16 U.S.C. Section 21, said that it's a tract of land in the territories of Montana and Wyoming. And of course, at that time, Montana, Wyoming, and even Idaho, they weren't states. They were actually not admitted as states until 1889 and 1890. And so when Yellowstone was created, they were territories over which Yellowstone was overlaid. Now, when Montana, Wyoming, and Idaho were admitted as states, Idaho and Montana each ceded to the federal government that portion of land that sat in their state. They gave exclusive control over it to the federal government so that it could regulate Yellowstone National Park. And that is in Idaho Code Section 5871 and Montana Code Section 2-1-207. And so there on the right, you can see the actual original document from Congress creating Yellowstone. It's kind of a cool document. Now, federal law is exclusive in Yellowstone. And so what this means is that under 16 U.S.C. Section 24, the federal government has laid claim to the exclusive jurisdiction over Yellowstone and the control of it. And this right to claim exclusive control over the land comes from the U.S. Constitution. It's there. Article 1, Section 8, Clause 17, and Article 4, Section 3, Clause 2. And on our next slide, we're going to look at 16 U.S.C. Section 24, and it says, "The Yellowstone National Park, as its boundaries now are defined, or as they may be hereafter defined or extended, shall be under the sole and exclusive jurisdiction of the United States. All the laws applicable to places under the sole and exclusive jurisdiction of the United States shall have force and effect in said park. Nothing in this act shall be construed to forbid the state the service in the park of any civil or criminal process of any court having jurisdiction in the states of Idaho, Montana, and Wyoming. All fugitives from justice taking refuge in said park shall be subject to the same laws as refugees from justice found in the states of Wyoming." So, the question now we have to answer as we come to the next slide again and we look at our map here again is, what federal district sits over Yellowstone? And Congress had a choice, of course, when the states were created and when the Yellowstone National Park was created. Congress could decide whatever it wanted to do because it has the sole power to define districts. And so it had a choice. It could have put all of Yellowstone National Park within the District of Wyoming, which is about 98% of the square miles anyway. Or it could have said, no, we'll have Yellowstone National Park in Wyoming be within the District of Wyoming, but we will have that portion of Yellowstone National Park in Idaho be in the District of Idaho, and the portion of Yellowstone National Park in Montana be in the District of Montana. It could have done that, but it chose not to. What it chose to do is create one district. And here we have that from 28 U.S.C. Section 131. And what Congress said is, Wyoming and those portions of Yellowstone National Park situated in Montana and Idaho constitute one judicial district. Court shall be held at Casper, Cheyenne, Evanston, Lander, Jackson, and Sheridan. And all of those are, of course, in Wyoming. And so this is a significant and ultimately fateful decision as we get to the question we're going to look at today, because what Congress, by its positive act and by its own affirmative choice, chose to do was to, for the first time in history, create a district that was not coterminous or within one state. It now overlaid multiple states. And that, of course, remember back to the earlier slide, we said jury must come from the state and district in which a crime was committed. And so you have the immediate problem that starts percolating into your legal mind as a curious lawyer subscriber here. The question starts popping up as to what do we do if a crime is committed in the District of Wyoming, but in the state of Idaho? Where does jury come from? Does it come from the state of Idaho, or does it come from the District of Wyoming, like way out in Wyoming and nowhere near Idaho? And what are we going to do? That sort of is what starts driving at the question we're going to get to. And so this is why it's important to remember that the Constitution guarantees a jury trial right, and that the jurors will come from the state and district where the crime's committed. On our next slide, you can see the free crime spree zone hypothetical. And so this is what we're going to now start looking at in terms of a hypothetical. And so what we can consider is that imagine that a crime is committed in the state of Idaho, but in Yellowstone National Park, that little sliver. And so make it up however you want. You know, you're going on a vacation and you decide that you're just going to engage in some crime. You're going to go to that little sliver of Yellowstone National Park in Idaho, and you're going to make some moonshine. You're going to poach some wildlife. Maybe you're going to strangle your spouse, steal some picnic baskets, whatever, right? You're going to commit crime. And you get arrested and you get arraigned. And then you're bound over for trial somewhere in Wyoming under, the federal law that defined the district for, where you're going to go to trial, because it's the District of Wyoming. And the jury then, when you're in Cheyenne, Wyoming, the jury is going to get drawn from Cheyenne, Wyoming, not from that little sliver of Idaho where you committed the crime. And so this is sort of what starts getting to the fascinating hypothetical about whether one can get away with committing the perfect murder or the perfect crime because of the inability to actually prosecute you. So remember, Article 3, Section 2 requires the trial to occur in the state of Idaho where the crime occurred. And the jury has to come from the state and district. Now, the District of Wyoming, of course, has exclusive jurisdiction over that portion of Idaho that's in the Yellowstone National Park. And so you'd need to go to Idaho, and that's the state under the Sixth Amendment, of course, with a jury drawn from that district where the crime occurred. Now, that may or may not seem like a problem, right? I mean, that portion of Idaho is in the federally declared District of Wyoming, and so, could you draw a jury from that small sliver of Idaho within the District of Wyoming, right? And if you can do that, what's the problem? You get a jury of your peers from the state and district where the crime was occurred. No big deal, right? There's only one problem. Go to the next slide. What's the population of Idaho in that sliver of land, those 50 square miles in the District of Wyoming? Turns out, population 0. There are no people who live there. And so if the jury is to be drawn from that sliver of Idaho, there is no jury. And if you've committed a crime that gives you a constitutional right to a jury trial, and they can't give you a jury of your peers, right, under the vicinage requirement, prosecution's got to get dismissed, right? That's the perfect crime scenario that we're looking at. So this is sort of a loophole that exists because of the quirks of how you look at the Sixth Amendment and federal law in terms of defining districts and the venue and vicinage requirements. And what would happen then ultimately is the court would have to impanel a jury from the local district in Wyoming. You're not going to waive your right to a jury trial. And you're going to demand that you be tried in the right place. They're not going to be able to do it. And you're going to demand the prosecution be dismissed. And the text of the Constitution is what it is. I mean, it says the jury has to come from the state and the district. Black letter law, it's clear, it's unambiguous, no problem, right? Well, let's look at some of the counter arguments against the literal language before we dive into some of the cases and we look at what may have actually happened to someone who may have committed a crime in one of these little crime-free zones. And so the Yellowstone loophole only exists if you take a literal view of the Sixth Amendment. Now, one can say that, but it's not tongue-in-cheek. I mean, it's hard not to take a literal view of the Sixth Amendment. I mean, the language is what it is, and it's, not really conducive to many interpretations. It says state and district. I mean, that sort of is one of those examples of pretty clear language. But if you were to try to argue that there shouldn't be a hyper-literal or a literal view of the Sixth Amendment and it should be interpreted in context, you would then unpackage the Sixth Amendment and go to the question of what's the purpose of this vicinage requirement. And the purpose was to prevent federal prosecutors from shopping for an anti-defendant venue and drawing the jury from there, to sort of avoid letting prosecutors pick and poach the perfect jury to convict a defendant and not let a defendant have a fair shake. And so an overlapping purpose was to guarantee that communities had some say in community standards, and they got to govern themselves in the criminal justice process by providing their citizenry to act as jurors on juries, deciding for themselves, what would constitute a crime or not in their own backyards, so to speak, as opposed to some other group of people deciding what is or is not a crime for their locality. And so some additional benefits, if not purposes, of the vicinage requirement that sit underneath the Sixth Amendment are that it guarantees that a trial will take place also close to where the facts occurred, which minimizes inconvenience and helps to ensure that fact finders are representative bodies with superior knowledge of local customs and norms. And so one context that you can think about this in is the context of course, the famed obscenity trials in the mid-20th century, 1940s, 50s, 60s, 70s, where the question was constantly raised about what is obscene. And, it was regularly drawn under First Amendment standards and principles, as you'll remember from First Amendment in law school, that the obscenity standard was defined by sort of the norms of the local community in part within their standards. And so a jury in Hollywood may well find that some pornographic film is not remotely obscene, but a jury in a very, very conservative state in the country, in a small community, may well find that same film is in fact pornographic and even obscenity, and could be prescribed and outlawed. And so that locality requirement was very important to allow local juries then to have a say in terms of what is acceptable and unacceptable within their communities. And so that sits underneath this. And so if you take that view of the Sixth Amendment and you look at the purpose of the Sixth Amendment, then the question of placing an entirely unpopulated portion of Idaho within the District of Wyoming doesn't really seem like a problem anymore, because the district is pre-existing. No one's trying to shove a case into Cheyenne, Wyoming and steal it from that sliver of Idaho. There's no one in that sliver of Idaho, so it wouldn't be calculated, manipulative, prosecutorial sort of blindsiding behavior that could justify not allowing it to happen. And when you get to the issue of allowing a community to govern itself, well, there is no community there to really govern itself. So the defendant is not going to be unfairly prejudiced by a jury being drawn from, Cheyenne, Wyoming, or some other part of Wyoming. Those are sort of some of the counter arguments. And so the question then this raises, as we go to the next slide, we're going to go back to 1891. We want to start looking at, well, has this come up, if not in Yellowstone, in other contexts historically? Have the courts grappled with juror vicinage requirements, being drawn and challenged and made when you have cross-border problems and border jurisdictional type disputes? And this brings us to 1891. And this is the Wild Horse Lake Massacre case, and it's called Cook versus United States. It's reported at 138 U.S. 157 in 1891 from the Supreme Court. The facts come from the 1888 Wild Horse Lake Massacre, and what occurred basically is the following. At that time, in the area of what is now the Oklahoma Panhandle, but at that time it wasn't Oklahoma as a state, there was an area of land that was well known as the no man's land, and it was sort of well known in the press, in popular lore, in cowboy folk stories, whatnot, that there was this sort of zone of land that was a no man's land. And it's in what's today the Oklahoma Panhandle, but it's land that at the time was outside any state or territory that existed within the continental United States land. And that occurred because of some simple drafting errors that occurred when the territories were being defined and states were being defined, and then Indian territories, Native American territories were being defined. And so the conflict of some drafting errors had created this sliver of land that didn't fit into anywhere. It didn't fit into a state, it didn't fit into a territory, and so it became just sort of known as a no man's land. It was a place where if you murdered someone or committed a crime, well, of course, you couldn't be prosecuted because you were outside the reach of the law, sort of the twilight zone of the 1800s. And so what happened is, of course, someone wanted to go test this theory, and there was a posse, and a Kansas posse of men went and attacked and murdered and killed a whole group of rival politicians in this area. And they sort of went out and basically hunted them, and there was a massacre there. A whole bunch of politicians were killed in 1888 inside no man's land. And they actually then went and sort of, I don't know if they were in saloons or bars or drinking moonshine or what, but they boasted of their crime, and they thought, we're free from U.S. law. No one can prosecute us. We got away with murder. We killed rival politicians. Eventually, this sort of made its way up to Congress, and Congress reacted, not surprisingly. A bunch of politicians in D.C. probably weren't excited about the idea that if they were dragged into no man's land and murdered, one could get away with it. And so, acting perhaps to protect other politicians or perhaps to protect the citizenry, who knows, nonetheless, Congress reacted. And they reassigned that zone to the Eastern District of Texas retroactively. So, what they said is, and here's the quote from the law they passed, "A United States court is hereby established, whose jurisdiction shall extend over the Indian territory bounded as follows, to wit, north by the state of Kansas, east by the state of Missouri and Arkansas, south by the state of Texas, and west by the state of Texas and the territory of New Mexico." And so, in effect, what that quoted language did was defined that otherwise no man's land area of what we call the Oklahoma Panhandle today, was now defined and reassigned to be within the Eastern District of Texas, and retroactively, so that it was now a sliver of land that had always been, or was retroactively defined to be the Eastern District of Texas. And so the result was that the murderers were then arrested, put on trial in the Eastern District of Texas, and were convicted of murder. And unhappy with their murder conviction, obviously, they said this is unlawful. Put aside the retroactivity issue, they just said that is a sliver of land where the law didn't apply. You can't go and define it after the fact and have us put on trial for murder and convicted. We, in effect, committed a murder in a no man's land, and we get to do that and get away with it. And so that's sort of at 30,000 feet, you can imagine, that's the high-level challenge to the supremacy of the law to judges that's being made, which is the idea that there's a zone where you can get away with crime free from the reach of law, right? Courts didn't like it. They were convicted, sent to jail, but cert was granted. The U.S. Supreme Court took the case. And so on the next slide, you can see, and by the way, that picture there on the right is actually Wild Horse Lake area where this actual massacre occurred. And that's a picture that came from the historical record taken at the time of where these murders occurred out in literally it looks like no man's land, as you can see. So the issue before the Supreme Court was whether, where venue is the state and the district, whether Congress could actually do this because the crime had not actually occurred in any state. Now, the Supreme Court was able to get around that vicinage requirement of state and district because it said, well, the crime may not have occurred in any state, but the Constitution has another provision which has a catch-all. And the other catch-all provision in the Constitution says that the trial shall be at such place or places as the Congress may by law have directed. And so what the Supreme Court said is, that may or may not have been the case, but Congress directed that it occur in the Eastern District of Texas. And so be it. That's an act of Congress. They directed it. You're okay. They haven't directed it for Yellowstone, but at least that's an example of the Supreme Court looking to find some other language in another act of either the Constitution or an act of Congress to not allow people to get away with crime. And so the conviction stands. The question we have to ask is, what kind of a shadow does that case cast? Does it cast a shadow that would apply here? It doesn't really, because the portion of Yellowstone we're talking about that sits in Idaho and Montana doesn't fit the catch-all, because it is precisely in a state as opposed to not being in a state. So the case is not on all fours. It wouldn't, allow a court to sort of just say, cite that case, too bad, you get to be prosecuted for your crime in that sliver of Idaho or Montana. But what it does show at a high level is that courts will find language and find ways to not allow people to get away with crime. And so from 1891, we're going to fast forward a whole century to 1992. And we're going to look at another case dealing with these sort of border disputes and border problems that trigger jurisdictional challenges and raise questions about whether one can get out of a criminal prosecution entirely. And so here, we're now going to swing down to Florida. And we have a case where the defendant committed a crime in the Southern District of Florida, in the state of Florida and in the Southern District of Florida. And that was the defined district at the time the crime was committed. But after the crime was committed, but before trial, Congress changed the districts, and they created a new district, the Middle District of Florida. And the defendant was now in the Middle District of Florida and was then bound over for trial in the Middle District of Florida. And the defendant argued that, no, I have to be tried in the state and district where the crime occurred. And the district where the crime occurred was the Southern District of Florida, not the Middle District. And so you can't try me in the Middle District because that's not where the crime occurred. And the 11th Circuit said, nice try, it's cute. It's a literal argument about the language, but nonetheless, it's too bad because Congress provided for existing cases to be covered by the new district. And so if Congress says that the district can be changed and existing cases will be covered by the new district, then your crime effectively did occur in, obviously, the state of Florida, but also in the Middle District. So you don't get to demand that you be sent down to the Southern District or demand that a jury be drawn from the Southern District. Now, one of the important points, though, that the 11th Circuit noted was that the argument wasn't just a cute one. I mean, it was a legitimate argument made under the Constitution and the Sixth Amendment's vicinage and juror requirements. And so the court took it seriously. It didn't just sort of pay lip service to it as just sort of a cute throwaway argument. And it noted that if there was ever a district shift, if Congress sort of altered the districts in order to try to change the outcome of a pre-existing case, then that may well be unconstitutional. And so they took seriously the idea that if districts are going to be altered or changed, and that's going to now affect where a jury pool is going to be drawn from, they want to be very, very careful and very, very sure that Congress didn't do that to alter the outcome of an existing case, to give an unfair advantage to the U.S. Attorney's Office or the prosecutors, or to unfairly prejudice a defendant by now suddenly redefining where the jury pool is going to come from. So, if Congress does it after the fact to convict what would otherwise be unconvictable, then yes, it actually would be unconstitutional. That wasn't the case here. It was just simply a very vanilla addition of a new district to Florida because of the need for more districts, because of the busy court dockets and courts, and so it was just a standard vanilla districting jurisdictional line drawing exercise by Congress. They didn't know anything about that case or any case. They didn't even care. And so too bad for that defendant. And so the important point here again is that facial border arguments, and we can call them border arguments, I guess, for lack of a better phrase, but these sort of facial border arguments that can track the language can be mounted, but they are rejected again. And so the court, other than noting that an extreme constitutional sort of scenario, other than that, case rejected, even though there was this literal argument about the language, because they found resort to other language of Congress. Now, let's go to 1980 at this point, and we're going to go to the case of Ziccarelli versus Dietz. And this case is reported at 633 F. 2nd, 312. It's from the Third Circuit in 1980. And so in this case, what we had is we have 7 indictments being returned against defendant Ziccarelli by a New Jersey state grand jury. And so this case starts in the New Jersey state courts. And the venue of the indictments against defendant Ziccarelli were originally laid down in Hudson and Mercer counties. But there was this ex parte proceeding by the assignment judge that transferred them from Hudson and Mercer counties to Burlington County when the Attorney General requested it. And the Attorney General of New Jersey had requested it under state laws that allowed the transfer of cases between counties. And so defendant Ziccarelli objected. He wanted to be tried in the county where the crime allegedly occurred, and within the state and district, and so argued that that's unconstitutional and it's not fair. And he did this on a habeas petition in federal court, which is why it's Ziccarelli versus Dietz is the name of the case, and that's what brings us into federal court, into the Third Circuit, ultimately. And the defendant argued that the Sixth Amendment's language says jury of the state and district where the crime shall have been committed. And the defendant essentially argued that he was tried in the state and district where the crime occurred, but he wasn't tried within the county within the district where the crime occurred. And so that's what was unfair and unconstitutional. There should be a county by county parsing of the district also, so that you can't be shifted to a different county. And ultimately the court rejected it. And what the Third Circuit said is that no, the district was defined broadly. You're tried in the state and district where the crime occurred, and there is no county by requirement within the district. And so what the court noted is that Congress is completely free to alter and revise the size of judicial districts to meet the needs and circumstances of the changing times at any time. And that is never a problem. It can never be a problem unless, like the other case we saw, that it's being done to affect a criminal case after the commission of the crime. And so this again shows another example of a case where parties try to parse arguments about borders between counties to get tactical advantages on jury pools and whether it's fair or right. And even though there are arguments to be made about not being in the district because of the county shift and where the districts line up over county borders, for example, again, here we have federal judges looking at it saying, nope, it says district, it doesn't say county by county. So even if by analogy, county by county is a part of district and you had you were shifted to a county where the crime didn't occur, too bad. Not going to indulge that kind of an argument. This brings us to our next slide, the case of Alvarado versus the state of Alaska. It's reported at 486 Pacific 2nd, 891, and it comes from the Alaska Supreme Court in 1971. Now, this case involved the defendant, who was an Aleut Indian, who was indicted for the rape of his sister-in-law after a heavy drinking sort of binge event. And he was indicted for the rape of his sister-in-law that was committed in his home community. And it turned out that this home community was a very, very remote and rural area, about 450 miles from Anchorage, and had a total population of 100 people, 95 of whom were Aleut Indians. Now, apparently from the opinion of the Alaska Supreme Court, the entire village almost the entirety of the village was related to each other. And there were about 14 houses in the village. And it was so remote that there were no TVs, there were no roads, and of course this is 1971, there was no internet, film, cell phone coverage or anything like that. And its entire contact with the outside world was built around one airplane per week that flew in some supplies and whatnot, and then flew out. And so that was the local community. And so the community, the 100 people that lived there, worked at a cannery part-time when it was open in the summer that was nearby, and then just engaged in sort of fishing for subsistence living. And they would make some clothes and whatnot that they would then, try to ship back to Anchorage for sale. And so what happened is, he is then indicted, and he's taken to Anchorage for trial, and he's bound over there. And the trial is then, set in Anchorage, and a jury is drawn based on the Anchorage jury rules from a jury pool within 15 miles of the city of Anchorage, which obviously didn't include his unique village or community 450 miles away. And, he's then put on trial, and that Anchorage jury convicts him. And so he then challenges the trial because of this vicinage issue about not being tried by a jury of his peers, that the locality he was tried in was just too far removed, too remote, and not representative or reflective of him. And some of the actual evidence, I'll read it to you here, and this is the testimony of one of his experts, and is a professor named William Babcock, who was a professor of sociology with a background of experience working in native villages, and this is being quoted from the Supreme Court of Alaska's opinion. He indicates that although most native villages are exposed to some extent to the effects of the dominant culture of the cities, the gap separating native villages from the mainstream of urban society is vast. Examples of the unique qualities of native culture given by Babcock encompass such factors as distinct sexual mores of the native community, childhood exposure to languages, cultural disorientation reflecting the imposition on the native villages of the dominant society's way of life, a distinct social history, completely different drinking patterns, and basic differences in family structure. Now, the court also went on to talk about what it referred to as the biographical and sociological evidence adduced below involving statistical presentation of differences. And so specifically what the Alaska Supreme Court said is that Alaska Natives comprise about 1/5 of the population of Alaska. Of a total population numbering around 150,000 in the 3rd Judicial District where this trial occurred, 1/10 were natives. And when the Anchorage area is considered alone, the native constituency drops to only 3% of the population. And so these were some of the facts that the Alaska Supreme Court looked at. And the court ultimately held that because of these profound cultural differences between what it referred to as the native villages and the urban areas of Alaska, the trial before a jury drawn from a panel which excluded virtually all the residents of the native villages simply couldn't be considered impartial or fair under the Constitution of the United States because the jury didn't adequately represent a fair section of the community from which the crime occurred. And so here I'll read to you the quote from the Alaska Supreme Court in terms of how it framed the holding. The narrow issue with which we are presented in this case then is whether, in view of the 15-mile restriction on jury selection, Alvarado's jury panel was drawn from a fair cross-section of the community. We recognize that the contours of a fair cross-section of the community are elusive, and indeed, that they may not be susceptible of precise definition. However, under the circumstances of the present case, we are compelled to find that Alvarado was not afforded an impartial jury as contemplated by the Sixth Amendment of the United States Constitution and by Article 1, Section 11 of the Alaska Constitution. We further conclude that failure to provide Alvarado with an impartial jury constitutes a denial of his constitutional right to due process of law. And so another part of what the opinion said is that, and this is another quote, because of the vast expanses of land which lie within the borders of our state, because of the variety of the cultural heritage of our citizens, and because of the relative sparseness of our population, the problem of selecting juries in Alaska is unique. And so the court recognized these unique difficulties that it was confronted with given the vastness of the state, the sparseness of populations, and this capacity to have this situation that was here of a crime in a remote village and then trying to try someone 450 miles away. But nonetheless, the court said he was not given a fair trial, fair jury, and his due process and Sixth Amendment rights were violated. And so that's a good example of where you have situations, obviously the complexity of the local community and the race issues that are present there obviously make it a significant case, but it's a good example of a case where testing of this border sort of issue and a fair cross-section of the community situation for a jury where the Alaska Supreme Court ultimately concluded that no, he couldn't be tried there, and so he'd have to be retried with a fairer, better jury pool. So, if you're thinking that you can go to Yellowstone to commit a crime, don't go just yet, because you want to think about what could happen. So let's go back to our hypothetical. You you hate your spouse, you go out, you say, hey, let's go on vacation. Let's go to Yellowstone. We're going to this little place called, this Idaho portion. We're going to like go in there, and you kill your spouse. Or you decide to go out there and go hunting. And so you take a gun, you drive through maybe a couple of states with your gun. Maybe you have a permit, maybe you don't. And you enter that little area of Idaho, and then you kill an animal. Or you go and buy a bunch of ingredients to make illegal liquor. And you buy all those ingredients, at a liquor store or a grocery store or wherever you buy moonshine ingredients in another state, and then you transport them into that sliver of Idaho, right? So you pick your perfect crime that you want to commit, but what you want to think about is that before you get to the question of whether you can get away with that crime in that sliver of Idaho by arguing that I want a jury from there, and there are no people that live there, so I can't be given a jury, so therefore I get out of the prosecution. You want to think about the fact that there's going to be a whole host of crimes that are preparatory to the crime you ultimately commit, where you take those preparatory steps, and that can trigger other laws. So it could be conspiracy or smuggling, illegal firearm possessions that are occurring in the states that you're crossing to get there. And all of those could be tried in those other states. And so you may well find yourself in trouble. There also could be, remember, and this is just sort of, again, a quick review in this Curious Lawyer fun series of some of our criminal law precepts, you may well be tried on lesser crimes where the sentence is less than 6 months in prison or jail, which means you don't have a constitutional right to a jury. It'd be a misdemeanor without a jury trial right, in which case you don't get to make that jury pool argument, and you're going to have a very upset judge in the District of Wyoming. And remember, there could be a whole range of civil liability. You may not get away with murdering your spouse, who may turn around and sue you for battery. Civil liability is not regulated or subjected to that kind of a regime, and so you'll have all sorts of problems there. So those are just a quick review of like accomplice liability, conspiracy, preparatory crimes and the like that make it such that you can't truly get away with anything and everything. Now, let's look at this on the next slide. What about these other Sixth Amendment interpretations we talked about, these other arguments? We've seen a bunch of cases dealing with other situations, but not this one. The Sixth Amendment, facially and unambiguously, requires a jury from the state and district. And the rationale is to stop jury forum shopping, as we talked about. Going to Wyoming doesn't necessarily trigger that. And so it's not about getting a favored jury, and that part of Idaho is within the exclusive control of the federal government. And Idaho doesn't have a particular interest in regulating people there. So, who cares? It's too cute by half, right? But let's look at it again. I mean, the Constitution says what it says, and it's not ambiguous. The language is unambiguous and clear. It's got to be the state and district. So how does one deal with that? Well, let's take a little sidebar and talk about this. The sidebar here is the law, Congress, and lobbying. And this whole issue about, the perfect crime zone was first identified by Professor Kalt in a law review article in the Georgetown Law Journal. And he identified this sort of funky loophole that exists because of the interplay of these jurisdictional statutes in the Constitution. And he wrote sort of a fun article called A Perfect Murder. It's a great article, you should go read it. That builds this idea of, oh my goodness, you actually could get away with the perfect crime by doing it there. And this is crazy that it exists, and it's easy to fix. And so what he did was, he published his article, and then he wrote to all the senators and congressmen saying, hey, look, this is crazy. Like, people could actually get away with crime there. No one ever intended this. Why don't you just pass a law to fix it? It's literally one sentence in the code that could fix it. It's an obvious error. No one ever thought about this at the time. And the other thing that was interesting for him when he went to sort of Congress and the Senate to go talk to them about it is that there's obviously no counter lobby, right? I mean, this is not a controversial issue. There's no one out there saying, no, people should be allowed to get away with crime in Idaho or Montana. And it was an obvious error. It's a Scrivener's error that's just sort of been identified over time because of the way Congress chose to define, the district. And you could just simply fix it by shoving that portion of Idaho into the District of Idaho and shoving another portion in Montana into the District of Montana. Who cares? Well, his article kind of got a little bit of notoriety. The Washington Post published on it. NPR did a program on it. Even the BBC in England did a program on it. Then there was a best-selling New York Times author who took the idea of this sort of this funky legal regime of sort of where you can get away with murder, and wrote a book sort of built around that sort of topic and idea of getting away with a perfect murder. And so this thing was on the news, it was on the radio, it was in the press. He'd even spoken, he was a law professor, he had spoken to his local congressmen and senators about it. And the result from our Congress was complete radio silence, of course. No one cared about it at all. They were totally indifferent. He couldn't get anyone's attention. In fact, in a hilarious anecdote in his law review article, which I really urge you to all go read, he talks about how he was really excited at one point when he finally got an email back from someone with like, a .gov email address asking him some questions about this. And he thought he was now finally speaking to a human being who may help create some language in Congress to fix it. And then when he replied to the email or something like that, it was, a dead email address because it had been a summer intern from some undergrad working for free who was doing who knows what, but his email response disappeared into the ether. Now, so that's where his situation had left him. But then, of course, what happened? Someone in Montana got indicted for a federal crime in that little sliver of Montana, not Idaho, but Montana, and they were aware of his article. So let's take a look at the case of the United States versus Belderain. And this is 07 Criminal 66 from the District of Wyoming, where Mr. Belderain, the defendant, was brought over for trial, and it's from 2007. And so here's what happened. You see the picture there of our beautiful elk. Mr. Belderain goes into Yellowstone National Park in that sliver of the Montana sliver, if you remember on our map, and he illegally killed and beheaded an elk. I mean, it's sort of a terrible, terrible thing to read about in the case, but that's what he did. And so he kills this elk, he beheads it, and takes the head back to his car, and then takes it to be, I guess, to a taxidermist or whoever the people are that stuff these things so he could put it on his wall. Well, in any event, through a whole conflux of funky and interesting facts, the federal government caught on to him in terms of what had happened, in terms of this dead elk body that was found, this beheaded dead elk. And eventually figured out that it was him because of sort of the service he had used to try to get the elk stuffed, the elk head stuffed. And they indicted him and they arrested him and indicted him. And remember, this crime occurred in Yellowstone National Park. The federal government has exclusive jurisdiction over Yellowstone National Park. Crimes that occur there belong to the federal government to prosecute only. And so they indicted him and brought him to the District of Wyoming, because remember, the District of Wyoming is the district for all of Yellowstone National Park. So he's dragged over to Wyoming to go to trial. Now, his lawyer decided, you know what, that's a really interesting law review article. Somehow the lawyer caught wind of it, I guess, and made the argument to the district court judge and said, wait a second, I get to be tried. It's fine in the District of Wyoming, but you need to hold my trial in the state of Montana portion, and I want a jury pooled from there. Now, turns out the jury pool there, it wasn't 0, but it's like 20 people or something that live in that portion of Montana. And so you're talking about him getting a very, very small jury pool that he probably preferred because maybe he knew some of those people, or maybe they were people who didn't really care about, the anti-hunting rules of the federal government, or who knows what. But in any event, he saw great tactical advantage to not going to trial in some more urban city in Wyoming and, getting some of those, 23 or 26 on people that lived in that part of Montana to be his jury pool. So he makes this argument. And, basically putting now before an actual district court judge this very argument we've been talking about, saying, the language is unambiguous. I want a jury from my state and district. You can't give me one. You need to dismiss. Now, let's take a look at his argument. Let's go to the next slide. And here is a basic quote. I pulled it on a 2-minute Lexis search. Statutory canons of construction, right? And this is from the U.S. Supreme Court from just a few years ago. And these are legion everywhere, as we all know. And it's really very, very clear. I mean, the first step is to determine whether the language at issue has a plain and unambiguous meaning with regard to the particular dispute in the case. The inquiry ceases if the statutory language is unambiguous and the statutory scheme is coherent and consistent. That basic canon of construction of language is one that governs our courts all the time. If the language of the statute, of the contract, is simply unambiguous and clear, it controls, and that's just the way the cookie crumbles, right? And that was his argument. It says the state and district. It's unambiguous. You don't get to create judicial exceptions to language because you don't like the outcome. And so it's not my fault that I can get away with a crime there. It's Congress's fault for, not passing a good law, and on top of that, having been lazy for the last 10 years and not fixing this, which they could have easily fixed if they'd listened to, our Professor Cult's law review article. And so that's his argument, basically, that he puts before the district court judge. And on the next slide, you can see, it's a near Twilight Zone decision from the court, really, when you stop and think about it and sort of apply basic principles of statutory construction. I actually here took a photograph of the decision for you, so you can believe me when I tell you this was sort of the entirety of the analysis of the court. The court says, quote, "The court must dismiss the defendant's objection. The District of Wyoming is the only district court that includes land in multiple states. Congress created this anomaly when it placed Yellowstone National Park in the District of Wyoming. The court recognizes the conundrum that presents itself because the literal interpretation of Article 3 and the Sixth Amendment make it impossible to satisfy both provisions when a crime is committed in the portions of Yellowstone National Park that fall outside the state of Wyoming. While the term state is often used in its more enlarged sense, there is no case law available to clearly designate such cases to the District of Wyoming." You can't make it up. That's the analysis. Basically, and then with the footnote there, you can see, the court recognizes the Georgetown Law Review article for its interesting esoteric value. However, it's of little practical value. So basically what the decision boils down to facially is, yes, I recognize the language literally says that, and literally his Sixth Amendment rights are being violated, but there's nowhere else to try him, so what do you want me to do? I'm not going to let him get away with it. He's going to trial in Wyoming. That is the syllogism the court employed. And all it could really say is that because there's no case having ever said you can do this, I'm not going to be the first to do it. And the language is actually kind of remarkable when you see that sentence. While the term state is often used in its more enlarged sense, often, always, right, Judge? That's the only meaning of that word. There is no other meaning of the word. So it's an obvious decision that's resort to legal artifices and arguments and sort of obfuscation, ducking, darting, whatever, put the guy on trial. So what happened to our elk hunter? He eventually pled guilty and got 48 months. The motivation is there to both, it should be there to not hunt and kill elk, but also be very, very careful if you make these jurisdictional arguments because you may not get out. Courts don't seem to care about the meaning of the language. So a little postscript here now is, let's go back to Congress and our sort of lobbying discussion and lesson. Surely now, right? At this point in time, the Department of Justice knows about this issue. The U.S. attorneys, from that district had to report it up the chain of command back to D.C. about, yikes, we have this problem. Like, Department of Justice, can you go knock on the doors of Congress and get them to fix it? We don't want to really keep having these problems every time, people come and commit crimes in the Montana and Idaho portions. Let's just fix it so the courts don't have to deal with it. Radio silence still. And here's a great quote from Professor Cult. He says, "As the old saw goes, laws are like sausages. It is better not to see them being made. I have spent 4 distasteful years seeing a law not being made. I can only imagine how unappetizing the scene will be if they ever do make it, but it's a chance I'm still willing to take." Now, the fundamental problem, of course, and this is sort of the dark side of the law, I suppose, here for us in this Curious Lawyer series, is that he didn't have a professional lobbyist, because had he had a professional lobbyist, he probably could have got the law passed. And that would have required him to invest money in getting Congress to fix a facial absurdity. So, our conclusions today are that constitutional law and venue and vicinage have very important rules. They come from, the common law back in England in the 1500s. They come from the pre-Republic era in terms of the founders' concerns about juries from the right area, regulating conduct in the right area to protect defendants and not allow over-aggressive governmental prosecutions. And so this vicinage rule of state and district is critically important. It's not just surplusage language or sort of acute historical anomaly, it's critical. It's critical to safeguarding constitutional rights, that we guarantee that there's a jury trial right in the state and district where the crime occurs. The literal language is what it is. I mean, it literally says that. It's really not susceptible to any other interpretation. And so the fundamental problem this thing creates is that there in effect is a zone in Montana and Idaho that really is a zone where you could commit a perfect crime. You may get busted for a whole bunch of other acts preparatory to it, or conspiracy or other charges, or lower, less than 6 months charges, but the technical, literal reading of the language is what it is. And we can't really depart from the literal language absent some remarkably compelling sort of canon of statutory construction that would let you get away with it. And as you saw in that district court decision, when a court was finally confronted with the exact question in the District of Wyoming, it couldn't do anything other than say, well, no case has ever done this, and so I'm not going to be the first, motion denied. So turns out Yellowstone does seem to have created a federal crime spree free zone where a perfect crime could theoretically exist. Now, of course, don't go do it and say that Peter told you you could do it. There's no way this can be construed as legal advice. I had to say that. Don't do it. It's not worth it. This is an issue, though, that's within the power of Congress to fix. It should fix it. It's easy to fix. It's frankly insane that Congress hasn't fixed it. Maybe someone from Congress will watch our Curious Lawyer series here, and maybe they'll get it fixed. And this is sort of the law's realpolitik, right? The collision of the Constitution as written, with judges looking at criminal defendants going free, not going to happen. The Belderain lesson is that you'll get 48 months, and no one cares what the literal language is when it's that significant an issue. And so what we see ultimately here, and one of our conclusions, is that we really have two Twilight Zone problems in the law here. One's in Yellowstone, in terms of what Congress has done to create this Twilight Zone area where you can literally get away with crime. But the other Twilight Zone problem, Congress itself simply can't get its act together to fix the most basic thing. Thank you for watching the Curious Lawyer program today. Hope you enjoy it and our other series. Stay tuned for more. We'll see you soon.